didn't know. You ready to go? Ladies and gentlemen, my name is Linton Mann. I'm the current co-chair of the Moot Court Board, and it's my honor to welcome you all to the 2007 Hardt Cup competition. While we're waiting for our judges to come down, what we're going to do is have Brianne Schwanitz, one of the authors of this year's Hardt Cup problem, actually describe to you the problem that you're going to hear. And when the programs become available from Kinko's, we will bring those into you as soon as they're here.
Thank you, guys. This is going to be a really exciting round. Both of our competitors have spent a lot of time with this problem, but since you are all unfamiliar, I'll give you a brief description. The facts in this problem are actually based off a case that will be going before the United States Supreme Court on April 23rd. The case is called Brenlin versus California. And the primary issue is whether passengers are seized for Fourth Amendment purposes during a traffic stop. The facts are that a officer pulled over a vehicle, and it was an unlawful stop because the registration tag was expired, but he had confirmed that there was a temporary operating permit. So he had no articulable suspicion for pulling over the vehicle, but did so anyway, found that there was a warrant out for the individual's arrest. In the facts of this problem, he decided to run the passenger's name because he noticed a bandana that signaled gang affiliation. And then once he found that there was a valid arrest warrant, he arrested the passenger, or searched the passenger and found drugs and drug paraphernalia. And so the passenger is contesting, or is moving to suppress that evidence. Also, the second issue is a Miranda issue as to whether or not when Miranda rights are read, they must include the explicit provision that you have the right to an attorney during questioning. In the fact pattern, the passenger was told you have the right to an attorney prior to any questioning. So the question is whether or not that was an effective reading of Miranda rights.
As I mentioned earlier, it is my pleasure to welcome you to the 2007 Hardt Cup competition sponsored by Thompson & Knight. After I provide to you a brief overview of this year's Moot Court program, I'll introduce our three Hardt Cup coordinators who are primarily responsible for everything going successfully, and they've done a tremendous job thus far. This year, we had the privilege of having over 130 student oral advocates participate in the Hardt Cup program. Those students logged over a total of 5,151 hours of service participating in the program. Our student judges, who were judging them through rounds 1 through 3, logged 966 total hours. And for all of the judges in the room, I also give you my sincere thanks for making it such a heartfelt and a wonderful program thus far. Special welcomes, of course, to Dean Bartlett and Dean Miller, who are here and continuing to give their special support to the Moot Court Board, and all of the faculty members who we will thank specifically in a moment. As you will see, the bailiffs are coming around now with those special programs we promised you earlier. Those of you who have been in here in the past, the reason that you'll see that they're so special is they're a lot more informative than we have done previously, and I think that you'll enjoy them. Moot Court at Duke Law is very special. An invitation to join the Moot Court Board is an invitation to do things in law school that you would otherwise not have the opportunity to do, such as participate in the various competitions that we send students to compete in. Throughout those competitions, we send teams across America. We even sent a team to London this year. We're very proud about that. We work with our team working skills because all of our competitions are with teams of 3 to 4. And we go through several practice rounds between student, alumni, and faculty members to prepare us for interscholastic competition. The successes of this year's Moot Court Board are numerous. We won the Whittier Law School Juvenile Law Moot Court Competition, winning Best Overall Team and Best Brief. The Regent Law School Constitutional Law Moot Court Competition, winning Best Overall Team, Best Brief, Best Oralist, and Third Best Oralist. We won the Howard Law Moot Court Competition, winning Best Overall Team. And we placed as semifinalist in winning 4th Best Brief in the Jessup Cup International Moot Court Competition. Our program is stronger than ever, and we're getting even stronger as we join today 20 new members of the board who gained their membership by being the finalist in the Hardt Cup competition. And if there are any of our newest members of the board, the one else who just gained their membership through the Hardt Cup competition, I'd like to ask you to rise today so that we can recognize you. Congratulations, and I will turn the program over to one of our wonderful Hardt Cup coordinators, Ramey O'Neill.
Thank you all for coming. So that you can more fully appreciate the significance of the arguments that you're going to watch today, I want to tell you a little bit about the Hardt Cup competition. The Hardt Cup competition is an oral advocacy competition for first-year students. It's completely intramural and it dates back to 1964. The cup itself was commissioned to honor the memory of A. Lee Hardt, a student who tragically died shortly after his first year of law school. The structure of the Hardt Cup is pretty simple. There are 3 rounds, and each student prepares a 10-minute argument. They argue first as petitioner, then they have a few hours off, and then they argue as respondent. So they get 24 hours to master a closed universe of case law and facts, and then from that information, they assemble these arguments. Round 1 is a mandatory part of the legal writing class here at Duke Law. Round 2 is when they receive a new problem and they have, again, the 24 hours to master the closed universe of facts and case law. And round 3 is exactly the same as that. The top 20 individuals are invited to join the Moot Court Board, and the top 8 individuals progress on to the quarterfinal and semifinal rounds. This year's competition was especially competitive. We had 204 participants in the first round, with 120 moving on to the third round. And those are record numbers for us, so we're pretty excited about that. So, today before your very eyes, Tim McGinn and Jim McDonald are going to vie for the 2007 Hardt Cup. Without further ado, I'm going to turn it over to Brianne to tell you a little bit about our competitors and about the judges that will be presiding today. Thank you.
As Ramey said, our 2 competitors today are Tim McGinn and Jim McDonald. Tim will be arguing for the petitioner. He's a 2006 graduate of Harvard. He majored in government, and he's a New York City native who spent the past 2 summers as a legal assistant for Wilson Elser in Manhattan. Jim McDonald will be arguing for the respondent's side. He's a 2005 graduate of Bowdoin College. He double majored in economics and government. And in between graduating from Bowdoin and coming here to Duke, he spent some time in Japan teaching English and traveling. We have a really excellent panel of judges today. Among our panel are 2 Duke alums and 1 district court judge. Judge James C. Deaver is United States District Court Judge for the Eastern District of North Carolina. He was confirmed to that position in 2005, and before taking that position, he had a distinguished legal career in both civilian and military practice. He got his bachelor's degree from Notre Dame, and he got his JD from Duke. We also have Justice Don Willet of the Texas Supreme Court. He was appointed to the Texas Supreme Court in 2005. Before that, he served as the Deputy Texas Attorney General for Legal Counsel. He had a triple major at Baylor and also got his JD from Duke. Then, as our Chief Justice today, we have Senior Judge Stephanie K. Seymour, who was confirmed as a 10th Circuit Court of Appeals judge in 1979. She served as the Chief Judge from 1994 until 2000. She got her bachelor's from Smith and her JD from Harvard. And so I will now turn it over to my co-chair, Brian Andrews.
All right, well, my job is to offer thanks to the several people who made this competition possible. First of all, I'd like to thank our sponsors, Thompson & Knight, for giving us money to run this competition, because a competition like this takes a lot of money to run, I found out. And also we'd like to thank Thompson Hine for co-sponsoring our reception that we'll have afterwards, as well as all the faculty, Professor Beal, Tom Metzloff, Jill Miller, Dean Miller helped out immensely with the program. Also to Nancy Cheek and Nick Jury for putting the problem up on the internet. The Alumni Development Office for offering up their rooms today for us, and for Media Services for taping the event and for setting up the room, and for Catherine Hall for giving us keys to the Moot Court room and to a lot of the other rooms in the building for the competition. And to Jim Maxwell, who is the National Moot Court team, who also came and did some rounds for us. He's the National Moot Court team coach. And without further ado, I believe we will go ahead and get started.
Oyez, oyez. Supreme Court of the United States is now in session to hear the case of Craig Woodruff versus State of Ochconsin. Let all who have business before this honorable court draw near and be heard. Chief Justice Seymour presiding, Justice Willet and Justice Dever accompanying. Oral arguments will last 20 minutes and petitioner may reserve time for rebuttal.
Be seated. Good afternoon. We are ready to proceed in the case of Woodruff versus State. Petitioner, would you introduce yourself?
May it please the court, my name is Timothy McGinn, counsel for the petitioner. I'd like to reserve 3 minutes for rebuttal.
Okay, and respondent?
May it please the court, my name is Jim McDonald. I'm the counsel for the respondent, the State of Wisconsin.
Petitioner, you may proceed.
May it please the court. This is a case that is first about the need to protect the rights of automobile passengers during unwarranted, invalid police stops of the vehicles in which they are traveling. And second is about the need to precisely inform vulnerable, detained suspects of their right to the presence of counsel during their interrogations in order to avoid both illegal coercion and unintended self-incrimination. This court should reverse the Ochconsin Supreme Court's decision for 2 reasons. First, the petitioner was neither free to leave nor at liberty to ignore the police presence under the circumstances and was therefore rendered seized within the meaning of the Fourth Amendment. Second, the police failed to notify the petitioner of his right to the presence of counsel during his questioning. As a result, there can be no ascertainable assurance that he was aware of this right as is required under Miranda. Would the court like a brief recitation of the facts?
Let me start, and we'll probably interrupt.
Thank you, Your Honor. Because petitioner was neither free to leave nor at liberty to ignore the police presence, he was seized within the meaning of the Fourth Amendment. This court has already held in the case of Delaware versus Prowse that the Fourth Amendment is implicated because stopping an automobile, singular, and detaining its occupants constitutes a seizure within the meaning of that amendment, even if the purpose of the stop is limited and the resulting detention is quite brief.
But counsel, we've had a number of cases decided since the Prowse decision.
Yes, Your Honor.
How do you distinguish Bostic, for example?
Well, first, this court made no ruling as to whether or not the person who was in petitioner's shoes in Bostic was actually seized. It merely remanded that case to the Florida court. But even under the Bostic standard, the petitioner in this case was seized. Bostic asks whether a reasonable person in the petitioner's shoes would feel that he was not at liberty to ignore the police presence under the circumstances. Given the show of authority inherent in a police stop, the officer coming up to the car after using his lights and sirens, the fact that in this case it was 3:20 in the morning and they were on a rural interstate, no person in the petitioner's shoes would feel as though they were free to leave in that case.
But in Prowse, and we didn't tackle the issue of passengers head-on. The language of Prowse as to occupants, plural, as to passengers, is dicta. And pure and simple, it's the legal equivalent of yada, yada, yada. We didn't tackle the issue of passengers head-on in Prowse.
No, Your Honor, but this court, it certainly suggests what this court's intent has been in the past, but even regardless of the Prowse dicta, the petitioner certainly meets the criteria under...
So you concede it was dicta in Prowse?
Yes, Your Honor, because in that case, the trial court had held that the person in the petitioner's shoes was the driver, even though the state trooper had testified that the petitioner was in the back seat of the vehicle. So for our purposes, it is dicta. But it certainly sheds light on what this court's opinion on this issue has been in the past. But
now, is the show of authority from the officer, and that's directed at the driver. I mean, to the extent a driver disregards a blue light of a police officer, it's the driver that will face legal consequences. I mean, the passenger ultimately is stopped just as a collateral consequence of being in the car. Just like in Bostic, isn't that right?
Well, the passenger is no less, his freedom of action is no less affected by the fact that the car is pulled to the side of the road. There's equally little guarantee that the reason for the stop is the driver's infraction, the driver running afoul of the law. It could be a seatbelt infraction. It could be because the passenger was littering. There's no guarantee from the outset when the officer pulls the car to the side of the road that he means to ticket the driver for some sort of infraction rather than the person in the passenger's shoes.
Looking back at Bostic, Bostic is our most recent decision related to passengers. So what fact or what facts distinguish Bostic from your argument today?
Well, in Bostic, the federal officers who were, or excuse me, the law enforcement officers explicitly said to the person who would be in petitioner's shoes in that case that they had the right to ignore the officer's questions, they had the right not to answer, they had the right not to cooperate. The officer in this instance made no such statement. We want to foster a public policy in which when people are pulled over to the side of the road, they don't get out of the vehicle and put the officer in danger. In fact, the officer will, more likely than not, merely order them back into the car.
Well, and if the officer directs that order at a passenger, then the passenger is seized at that point, right? I mean, that is a show of authority directed at the passenger, but absent that showing of authority, how under Bostic does this lose its consensual nature?
Bostic imposes a reasonable person standard. A reasonable person would not get out of the vehicle after it was pulled over to the side of the road, even if he was not the driver, because we are while we are not particularly well-versed in constitutional law, the average or reasonable citizen is well-versed in television programs like Cops, is well-versed in being pulled over to the side of the road, and has seen what happens to a person who gets out of a vehicle during a police stop, and would be very, very unlikely, particularly...
What about the Slater case? I mean, the Slater case, there was a stop, someone was tested for DUI, the driver was, and the passenger got out, used his cell phone, called somebody to come pick him up. I mean, how do you deal with that case?
Well, Slater, first of all, there was a temporary seizure when the person was ordered out of the vehicle, but the circumstances were dramatically different, and these really are case-by-case bases. It needs to be applied on a case-by-case basis. In that case, people were able to walk away from the stop. There was demonstrable proof that several other people who were stopped at this sobriety checkpoint were able to leave. In this case, it was a rural interstate during the middle of the night. There was the possibility of calling someone and telling them to come pick them up in the middle of nowhere when the petitioner may have had absolutely no idea where he was is very unlikely.
Counsel, why do we care if the passenger doesn't feel free to hop out of the car on a highway in the middle of the night? Isn't the real question is whether the passenger feels free to decline to answer questions?
Yes, Your Honor, but a reasonable person would not feel free under those circumstances to decline to answer an officer's questions. Americans, as a matter of public policy, we want to encourage them when a police officer asks them a question to answer the question the officer poses to them. The average reasonable person would not feel as if he were free when the officer was leaning over the window into the car, directing a question at him, as though he had no obligation to answer it.
But the officer's not on the passenger side, he's on the driver's side.
Nevertheless, Your Honor, he is obviously asserting his authority merely by stopping the vehicle and by placing his hands on the car and directing questions to individuals inside the car.
Mr. McGinn, you mentioned the TV show Cops. And we all also watch 24/7 Law and Order. We've all seen Law and Order. We all know you can have a lawyer at any time. And your client's been around the block, and he once said these 8 words: "Lawyers have never done me any good before." I mean, that tells me he's pretty savvy about the role of lawyers when it comes to questioning and interrogation. And why should we not factor in your client's previous experience with criminal interrogations? Why should we insist on some gotcha-style, hyper-technical formalism?
This court has explicitly said in its previous holding in Miranda that we ought not engage in ex post facto analysis as to whether a person in the petitioner's shoes was aware of his rights. Generally, the people who are most likely to be confused as to what their rights are going to be poor, less intelligent people who are already vulnerable within the criminal justice system. These are the people who have to have the utmost of safeguards provided for them.
But he was told that he had the right to remain silent, and he was also told he had the right to have a lawyer for free.
Yes, but as this court has also previously held, these other rights, without having some sort of legal guardian there, a legal representation to protect those rights, can easily be overridden within the interrogation process. Obviously, police officers wouldn't be very good at their jobs if they weren't particularly skilled in teasing out information from suspects who did not want to incriminate them.
So is your attack on the Miranda warning that it didn't include the phrase "you're entitled to a lawyer during questioning"? Because the actual warning said you're entitled to a lawyer before questioning.
That's correct, Your Honor.
Well, how do you? I mean, in Duckworth, there was a whole analysis by this court of a warning that said you're entitled to a lawyer if and when you go to court, so that in the future time, and we found that within the totality of the warning given to be consistent with Miranda and its progeny. I mean, how do you distinguish Duckworth?
That's true, Your Honor, but the more relevant analysis within the Duckworth case specifically dealt with the intersection of two specific warnings that were given by the police officer in that case. In that case, the police officer said you have the right to the presence of counsel before questioning, and they also said you have the right to stop answering our questions and consult with counsel mid-questioning. You're allowed to break off questioning and consult with an attorney. Taken together, those were viewed as covering the right to retain counsel, the right to have counsel appointed during questioning. That's not present here. Here, all we have is the petitioner being told that he has the right to presence of counsel before questioning. There was never any warning given that he had the right to call an attorney, consult with an attorney during questioning. And as a result, the Duckworth standard, or the warning that was approved by this court in Duckworth, that standard is not met here. Because a reasonable petitioner might not think that he had the right, after questioning had already begun, to invoke this right to counsel. This court has already explicitly distinguished in Miranda between the right to counsel before and the right to counsel.
Mr. McGinn, usually people are searched. The cops find some kind of contraband or a weapon or whatever, and then they arrest that person. But here, even if the stop was invalid, as the state now concedes, why should we suppress evidence when the search was made only after your client was arrested? Why should we? I mean, it resulted from him freely handing over his identification. So the cops came up to the car, they discovered there was a warrant out, they arrested him, then searched him, and found the contraband. Does the timing of what they found matter?
No, Your Honor, it doesn't. In this case, first of all, he did not freely give over this information. Yes, he volunteered the information, but given the circumstances...
He volunteered it, but it wasn't free.
Is it your position that on the valid arrest warrant that was issued, in light of the fact that he gave his name, that he would not be subject to prosecution under that arrest warrant because giving the name was involuntary?
Giving the name, yes, giving the name...
So it's your position that not only should the drugs that were found on him be suppressed, that the state would not be able to prosecute him on the arrest warrant that was outstanding, that prompted the search incident to the arrest? Is it your position that his identity should be suppressed as well as these drugs?
No. Obviously, the state, I think, should be able to prosecute him under the circumstances. That's not the question that's before them, that I'm pushing before the court today. I think...
Well, if it's then a lawful arrest, why doesn't the search incident to the lawful arrest purge whatever taint was associated with the stop originally?
Everything that came in after the arrest, the police may have arrested him, may have followed through on this warrant, and arrested him under other circumstances. So for that reason, it doesn't seem necessary to prevent him from being prosecuted under the previous warrant. But because of the fact that nothing about this interaction between Mr. Woodruff and the police was voluntary, because of the inherent power imbalance, everything that came in after the police officer detained him, seized him, within the meaning of the Fourth Amendment by pulling the car over the side of the road.
But you just are then saying that his identity should be suppressed. You're saying he was seized and everything else follows. I mean, isn't but-for causation not enough? I mean, to say that everything afterwards?
In this case, what was crucial was not merely his name, but also the gang bandana as well. When he was seized, the Bostick standard says, able to ignore the police presence. Concealing a bandana, no matter what he was doing in the car, he was not going to be able to conceal that he was wearing this particular article of clothing. That is more important. That is more relevant than his name, because that is what triggered the search of the database. That is what encouraged the officer to run his name to see if there were any outstanding warrants. It's not merely the name, but also the fact that the officer seized on something that he was wearing
So you're saying he wouldn't have observed that if he hadn't unlawfully stopped the car?
That's correct, Your Honor. There would have, not only would he not have acquired the petitioner's name, he would not have seen this gang bandana, he would not have run the name as a result, and the petitioner would therefore not have been arrested. So
Mr. McGinn, Racus strikes me as fairly on point. We said in Racus, a passenger has no legitimate privacy interest in a car's interior. I mean, how do we sidestep Racus?
This court, yes, obviously, this court did hold that in Racus, but that dealt with, if I'm not mistaken, more directly the seizure of, the search, rather, of the vehicle, and not with the stop of the vehicle and the seizure of its passengers. There was nothing about, the car was not searched, so nothing that the petitioner possessed within the vehicle was taken. So this does not square exactly with this court's prior holding in Racus.
Let me ask you this. This may strike you as a little out of left field. Why shouldn't this court give serious thought to scrapping the exclusionary rule altogether? Why shouldn't this case be an occasion to scrap the exclusionary rule?
If the court does that, it will obviously undermine significant safeguards for the rights of every.
Because it strikes a lot of people as a very formalistic rule that imposes a terribly high burden on law-abiding society. So why shouldn't we reconsider it?
If you were to scrap the exclusionary rule under these circumstances or at all, you would only encourage tactics like those employed by Officer Gerlach. You would encourage stops that have very questionable underlying motivation. You would encourage officers to use the flimsiest of excuses to stop vehicles, to interrogate their occupants, and try and tease out some sort of crime, some sort of evidence of criminal activity where there was none before. And it's for that reason, that public policy reason, the interest of protecting people's rights and protecting them from this sort of arbitrary intrusion by the state, by the police, that you ought not scrap the exclusionary rule altogether. To directly address the Miranda issue, as mentioned before, in Duckworth, this court explicitly held that when a police officer warns that one has the right to have counsel present prior to questioning, when that extra language is added in, there must be some other term that keys the person in the petitioner's shoes, a reasonable person in the petitioner's shoes, off to the fact that he has the right to have counsel present during his questioning. Miranda explicitly held that we must have we must be able to have an ascertainable assurance that they are aware of this right. At the point at which this court is asking whether the petitioner was able to infer whether he might have known, then the police has failed to meet its burden. This court also held in Duckworth that one of the vital bases was explicitly this right to have counsel present during questioning, as distinct from the right to have counsel present prior to questioning. It's obviously very different when you're able to consult with an attorney prior to, as that counsel may be overridden by the interrogation tactics employed by the police.
In deciding whether we should reverse on the Miranda question, do we look at how the defendant responded to the warning? For example, if a defendant says after a warning, such as in this case, that, which he pretty much did, I don't like lawyers, they haven't done me any good in the past, I don't want one. Can't we infer from that if you said anything more, he still would have rejected a lawyer?
No, Your Honor. That's exactly the sort of ex post facto analysis that this court explicitly rejected in Miranda. I see my time has elapsed. May I finish my thought? That's exactly the sort of ex post facto analysis this court has previously rejected. Ascertainable assurance sets such a high standard that the police must explicitly inform someone in the petitioner's shoes of his right to have counsel present during questioning. Thank you.
Thank you, counsel. Mr. McDonald.
Madam Chief Justice, and may it please the court. The precedents of this court and at a more basic level, common sense, require that the petitioner's appeals must fail. First, A seizure has not occurred in this case because it was reasonable for the petitioner, Mr. Woodruff, to believe that he was free to ignore the police questioning that night and go about his ordinary business. Further,
Didn't we decide this question in Prowse?
no, Madam Chief Justice, this court did not. The facts of Prowse were quite distinct from the issue here. As has already been pointed out,
Except in Prowse, didn't petitioner actually give away too much? There's a footnote in Prowse that mentions the fact that although the state Supreme Court had said that Prowse was the driver, what the arresting officer testified that he was actually an occupant in the back seat.
yes, although the petitioner did concede that the Prowse was dicta, the facts of Prowse left some ambiguity, and the reason this court used the word occupant is because of that ambiguity. It did not specifically hold for passengers that there was
Don't we
no
assume
seizure.
that if there was some ambiguity and there was evidence that it was the passenger, don't we assume that the court, when it talked about occupant, was including that passenger?
That's not a necessary assumption here. Indeed, in the last paragraph of Prowse, there is some indication the court does use the word driver, that they were, in fact, that this court was, in fact, targeting the driver. And nothing there would prevent this court today from clarifying its position and reaffirming the positions of the cases that have followed since Prowse, which have narrowed the rules of seizure and balanced the rights of the police and the state. In both Mendenhall and Bostick, this court reaffirmed the right of the police to approach a person and question them without.
But in Bostick, the defendant was already stopped. The bus was stopped,
Yes.
correct?
Yes.
So
but-
isn't that a totally different circumstance?
Madam Chief Justice, in both cases, the vehicle was not moving. On the bus, when the police approached, the passengers were simply sitting there, as the passenger, Mr. Woodruff, in this case, was sitting there.
But he wasn't sitting there until the officer stopped the car.
The pulling over of the car was the least common denominator, one could say, for pulling a vehicle to the side of the road. The officer approached the other side and simply addressed the driver. The passenger was not in any way implicated at that point.
Why wouldn't Bostick, if anything, cut the other way? And wouldn't a bus passenger, somebody crammed in like sardines on a bus with 24 other people, have a lesser or lower expectation of privacy than somebody driving in a Mini Cooper, say?
Well, Justice Willett, the question isn't whether a person is free to run around the bus or jump around the bus. It's whether they're free to ignore the questioning of the person that is asking them, in this case, the police officer. And whether you're on a bus or you're in the passenger seat of a car, a reasonable person, which is the standard, would feel free to ignore that questioning. And that is why this case does not amount to a seizure.
But you really can't say that Woodruff was entirely free to leave, are you? I mean, this was not high noon on the corner of, Tower View and Science Drive. This was 3:20 in the morning on a desolate stretch of highway on I-27. How can you say a reasonable person? This is not, Jack Bauer we're talking about, a reasonable person. And that was the test we set forth a quarter century ago in Mendenhall, a reasonable person. And how would such a person feel 100% free to exit a car and wander off at 3:20 in the morning?
Well, Justice Willett, again, this standard from Bostick is not freedom to leave and wander off and go play hockey on the side of the road. It's the freedom to ignore the question. A person could sit there and smoke a cigarette, carry about his business, fall asleep in the passenger seat. There was nothing that required him to get out of the car, and none of this court's precedents require him to get out of the car and walk away. Indeed, no one would ever tender the argument that it would be a good idea to start walking along an interstate highway at 3:30 in the morning. It's not that the police were there that made walking along the highway a bad idea. It's that walking along the highway at 3:30 in the morning is a bad idea. The seizure itself had nothing to do with this. Again, returning to the Mendenhall.
The officer's focus is on the passenger of the car when he stops it. Does that change anything?
Certainly, Your
Does that
Honor.
mean the driver isn't seized?
Certainly, Your Honor, it would depend on a different factual situation, but this court, in Terry, for instance, pointed to certain objective standards that can be used to determine who is the target of the seizure, whether there's touching, whether there's yelling, if there's a weapon drawn, if there are multiple officers present.
None of those were present in this case,
None
and
of them.
somebody was seized. The driver was seized.
Yes, Madam Chief Justice, the driver was seized in this case.
I mean, isn't, in Prowse, the driver, per se, when they're blue lighted and pulled over, the driver is seized, right? You would concede that's not some separate factual inquiry, is it?
Yes, the driver was certainly seized, but the question is quite distinct as to whether the passenger was seized.
Well, you started off with a nod to common sense in your opening to the court. I mean, and I agree, sometimes common sense has a place in the law. And isn't it common sense to conclude that a passenger is unavoidably seized when a car and driver is seized, as our Chief Justice noted when she was a lower court judge in Irwin?
As this court has said before, it's a reasonable person would believe that they are free to simply sit and be quiet and carry about their everyday business. It's not the view from the unique idiosyncrasies of the petitioner in this case. It's a reasonable, everyday, innocent person. An innocent person who has nothing to fear from the police would in no way feel that they were under threat from a police officer speaking to the driver of the car in which they were riding. And that's the situation here. As this court has repeatedly emphasized, the objective standards of whether there's a weapon drawn or whether they're shouting really make this a very simple decision for this court and in terms of whether or not the passenger felt any pressure or loss of privacy from the officer who was questioning
If we
them.
conclude that in fact this is a seizure, do you concede that the evidence ought to be suppressed?
If this court did conclude that it was a seizure, yes, the exclusionary rule would be probably applied to this case, but certainly that would go against the previous 25 years of what constitutes a seizure for this court and narrowing this rule to balance the rights of the states.
Let me ask you the same left field question I asked your counterpart. Should we use this case as a vehicle to reconsider the exclusionary rule altogether?
No, Justice Willet, the state of Ochconsin does not in any way advocate that the exclusionary rule be thrown out. It does serve a valuable purpose, especially to curb police abuse. In this case, however, there was no police abuse when it came to the passenger. Throwing out the exclusionary rule would remove all of the rights of one side of this debate, and it is a balancing test between the rights of the state and the rights of the individual. And in the state's opinion, that would certainly be an extreme and unwarranted decision for this case.
Isn't one of the things we consider in this history of cases of ours that you talk about in deciding whether there's been a seizure, whether the officer approaching the individual does so in a public place with other people around, which was true in Bostick, it was true in Mendenhall? We don't have that here.
No, Madam Chief Justice, that's not present here. But again, a reasonable person who had nothing to fear from the police would in no way feel that they were implicated.
That's assuming that sort of begs the question. Aren't you just assuming that a person would always feel free if they're innocent not to respond?
A person well apprised of their rights and nothing to fear of the police, this court should not fall prey to the certain predilections of the cop show, as the petitioner pointed out. Again, in that show, people are afraid of the police because they've been running from the police for many blocks in high-speed cars. They're not simply pulled over to the side of the road. Here, a reasonable person could simply have smoked a cigarette or fallen asleep, which in most cases is probably what would have happened if the petitioner hadn't been so alert, knowing that he was, in fact, a wanted felon. As we look at the Miranda issue, the Miranda procedural safeguards are met quite simply when a person is advised that they have the right to an attorney in the present tense, and that is so in this case. The Miranda safeguards are meant to ensure that a person is not told that they have an attorney only when they go to trial. Indeed, it's the preparation for the initial police questioning that can be so important for the individual.
Why did we so emphasize in Miranda then that it was exceedingly important that they know they have the right to attorney during questioning?
Madam Chief Justice, this court was working from a very different baseline in Miranda, where the petitioners there had no rights explained to them at all. And this court was for the first time instilling the rights that Miranda provides. Here, this court has for the last 25 years, again, balanced the rights of the individual and the necessities of common police work with its Miranda progeny. And in this case...
But in each of our cases where we said a particular warning was okay, the defendant was, or the person about to be in question, was always advised they had a right to an attorney during questioning. So they're not helpful to you, are they?
They are very helpful because they certainly reaffirm what this court said in Miranda, which is that it creates no constitutional straitjacket. Again, a person advised quite simply that they have the right to an attorney at this moment should not interpret that in any common sense understanding of the word to mean right now, but never again.
What if it's ambiguous?
In this case, Madam Chief Justice, it certainly wasn't ambiguous, and the type of ambiguity obviously would change the facts of this case, but here, certainly it would
If
be,
it's ambiguous, do you lose?
if it's ambiguous as to whether the petitioner was told, certainly I think the facts here that the petitioner was told that he had the right to an attorney before questioning are not ambiguous, and it would require some real stretch of the imagination to turn before to before, but never again. And that would certainly go against the strict reading of Miranda that this court has never affirmed. Further, the Prysock and Duckworth decisions have, again, narrowed when Miranda rights are properly applied to an individual. In both of those cases, this court has reaffirmed that a strict formulation of Miranda is never necessary. A rigid standard is not in the best interest of the police of this country, nor in the best interest of the individual, who, under fear of the police presence in an attempt to avoid intimidation and coercion, is simply looking for the basic facts of his rights, which are, quite simply, you have the right to remain silent, and you have the right to an attorney whom you may talk to at this point if you so desire. And again, looking at the facts of this case, that is present.
Rakus said passengers cannot challenge an automobile search. They're not entitled to challenge the search of a car that a third person is driving. But why should we apply that to the search of a passenger's person, his or her own physical body?
Why should the Rakus decision not be applied to the, could you say that question one more time, Mr.
Rakus says passengers are not entitled to challenge an automobile search.
Yes, they lack standing.
So why should we apply that to the search of a passenger's own person, his or her own physical body?
This court should not really rely on Rakus for this case. It should again rely on the idea that a person is seized within the meaning of the Fourth Amendment, quite simply when the show of authority to them is overwhelming or gives them some indication that they are not at liberty to leave the scene or
Well,
to...
if the defendant isn't seized at the time that the car is stopped, why isn't he seized at the point that the armed police officer, your opponent, and you'll have to tell me if it's in the record, I don't recall reading, but your opponent said that he physically leaned into the automobile and directed to the defendant that he tell him his name. Why isn't at that point, even if the blue lights don't cause a seizure, which is your position, why isn't there a seizure then when he is directing his show of authority at the defendant?
Justice Deaver, the state does not contend that he was directing his show of authority there. He was simply asking for voluntary information, as an officer walking down the street might ask any person they happen upon for some information in the everyday course of police work, simply perhaps to make the passenger feel more comfortable, simply perhaps to see if he could get any information out of that in the name of good police work. But of course, the question is, what should the passenger have done in that instance? And in this instance, the passenger...
How is a reasonable passenger going to be made more comfortable by telling the police his name? I don't understand that.
Certainly, Your Honor, a passenger may choose to be friendly in some situations, as any person would when they encounter the police. Again, the police are not the enemy in this situation or ever. The question is, should a reasonable person who volunteers information reasonably expect that the police may use that information, and certainly he should expect that. And that's why, since it was not a seizure, this court should again consider that this was properly applied evidence to this case. But
If we're not going to throw out the exclusionary rule, doesn't the rule that you want us to apply totally open the door for illegal police conduct? For example, racial profiling. The car might be stopped in a high-crime area because the officer is racially profiling the passenger as well as the driver.
Well, Your Honor, there are several things I think that caution against that type of slippery slope analysis. First, following the Bostick decision, there wasn't a run on buses. The police did not begin to overwhelm people on buses and begin asking question after question, and there's no reason to believe that the police would do that in the car situation, especially since troopers on the side of the road can only see cars passing them at 65
How
or
do we
70.
know that about Bostick? And I think it's fairly common practice for officers, especially near the border, to get on buses and trains and ask questions.
Yes, it is, Madam Chief Justice, but this court has also recognized that there are certain exceptions from the Bergoni-Ponce case when it relates to border inquiries. And certainly around the border, there may be certain exceptions which are not properly applied to the rest of the country. And I've ridden the buses, I think most of the people here have ridden the buses, and there certainly is that overwhelming fear of people when they board a bus that they're going to be subject to strict police questioning. And there's no evidence that this court has ever found that police are overwhelming people on buses currently and violating their constitutional rights to remain silent. But if that did happen, of course, this court would want to revisit that issue. But I think that cautions against the slippery slope analysis. Additionally, the car traffic...
Why is it a slippery slope? Why isn't it easier just to have a bright line rule? If you stop the car, you're stopping everybody in the car.
Again, that would go against the precedent of this court, where there have been certain exceptions. Again, the Fourth Amendment requires a balancing of state and individual interest, and to have a bright line rule like throwing out the exclusionary rule the other way, again, removes the entire state interest in this important field of law. And as this court has said, the exclusionary rule takes a heavy toll on society every time it is applied. It is important in certain circumstances, but not in every circumstance. And it is for that reason that a per se rule is not appropriate in this case.
Let's change the facts and pick up on the Chief Justice's hypothetical. This happened near the border. Under the rule that you propose here, the police could stop a car. The town is 20 miles from the Mexican border. They could see, anytime they wanted, they could see a car with multiple Hispanic individuals in it. They would know, under the rule you're advocating, that they're seizing the driver without any basis under the Constitution, but that if they happen to find an illegal alien in any of the other parts of the car, sitting there in the passenger seat, in the back seat, those individuals would be subject to prosecution. Is that right?
In that circumstance, obviously, it would be far removed if there began to be continuing roving police patrols. But this court, of course, has already said in Bergoni-Ponce that those type of roving patrols that where no probable cause for pulling over a car is present are valid in the border or its functional equivalents. So this court has, in some sense,
reasonable suspicion.
there was some standard of, it was a less than reasonable or less than probable cause standard, but a reasonable suspicion standard. Yes, that's correct, Madam Chief Justice.
Right, but here on our facts, you're saying where there's no basis, admitted, I mean, I thought the state admitted that in light of the valid registration, there is no basis. So under the rule that you're advocating, the police in and around the border or anywhere else could stop a car. They could prosecute any individual passenger for being illegally in the country, and those individuals would not have the protection of the Fourth Amendment. Is that right?
Well, Justice Deaver, I believe the border situation in this conflates the issue. Removing it from the border, a person pulled to the side of the road, the passenger, the state argues, does not have the reasonable expectation of privacy or does not have the necessity for privacy, as Rock has said, where the exclusionary rule would be properly applied. Again, it's a reasonable person, an innocent reasonable person, could feel free not to cooperate, and that is simply the standard that needs to be applied in this case.
Is our decision about what a reasonable person would do informed by the fact that a majority of the circuit courts have held that this would constitute a seizure?
It's certainly helpful information, but it's in no way binding. There have been obviously a major circuit split, which is partially the reason this is before the court today. But again, the circuits can, in their own facts and situations, deviate. But this court, knowing its precedent better than any court, will be able to determine what the previous 25 years have, which is that this rule has been narrowed to allow for the balancing of the state and the individual interest. And in the continuation of that narrowing, it is proper here to say that the passenger was not seized and to continue drawing the fine lines that this court has continually done between border and non-border, between passenger and non-passenger in applying the exclusionary rule. And here a line can be drawn quite clearly between a driver who has some expectation that he is under suspicion when he is pulled to the side of the road, and a passenger who does not have that expectation.
So the fact that crime in the area has really skyrocketed a lot in the last few years. Should that play any role in informing our view of the law?
No, Justice Willett. In this case, it really should not have any effect. Just like the individual idiosyncrasies of any case should not play into the scope of the objective reasonable person. And it's that objective reasonable person standard and the precedents of this court which inform the decision on the matter of the seizure. And it is, as Judge Wilkinson of the Fourth Circuit said, common sense which should inform as to the Miranda rights. And it is for these reasons that this court should affirm the Supreme Court of Ochconsin. Thank you.
Thank you, counsel. Some reply, Mr. McGinn?
May it please the court. The respondent notes that there was no shouting, there were not multiple officers, there were no guns drawn in this instance, but the circumstances of Terry were dramatically different from those present here. This court obviously would not want to foster a standard in which when a police officer walks down the street, everyone who happens to be on the block is rendered seized. That's why Terry requires certain other factors in order to consider a person who is having a conversation on a street corner with a police officer to be seized. Here, however, the force, the yelling, the screaming, the drawing of a weapon noted in Terry is embodied in the blue lights, in the sirens, in the inherent power imbalance that results in being pulled over to the side of the road. Now, respondent contends that the reasonable person would have no qualms whatsoever about ignoring the police requests. But this fails to acknowledge this power imbalance, the fact that the police officer is an agent of the state, has the power to arrest, and most reasonable individuals or most citizens are not well apprised of that.
And you agree the test is a reasonable innocent person, not a reasonable crook, right?
That's correct, Your Honor. The petitioner concedes that. But a reasonable person wouldn't feel any less free to refuse his name. A reasonable innocent person would have no reason to refuse to give his name. So he would merely do it in order to not prolong an encounter with the police from which he had nothing to fear. Because of the imbalance, this court has found in both Mendenhall and Bostick that in cases in which the person's rights are explained to them merely through a warning, you do not have to participate, you do not have to cooperate, you do not have to answer my questions or consent to my search, that they're right, they were informed by that. The power imbalance was offset by this warning, by the fact that they were made aware of their right to decline. There was no right to decline here, and because of the power imbalance, the burden is placed on the police officer. It's assumed that you are going to cooperate because the police officer has this power over you. To address the Miranda issue, there are obvious touchstones, baselines that need to, baseline rights that need to be explained, as this court has already ruled in Duckworth. One of them is the right to have counsel present during questioning. The addition of other modifying language that confuses the situation, that makes the petitioner unclear of his rights, is unacceptable, and it must be, it's therefore unable to, it prevents an ascertainable assurance.
Counsel, in analyzing Miranda and thinking about advising accused of their rights under the Fifth Amendment, don't we have to take into account that quite often a police officer is out in the field doing it, sometimes, and I know it wasn't the fact here, but it has perhaps just engaged in a foot pursuit and literally has just taken custody of an individual and is then reciting the rights without pulling out a card, in part because they're using both of their hands to try and control the individual who has just been captured. And so in looking at, isn't that the point of taking a sort of a common sense view? I know Respondents' Counsel mentioned Judge Wilkinson's opinion. I mean, why isn't that, isn't the rule you're advocating going to ignore the reality of where Miranda warnings are given quite often in real life for folks who have just been caught?
I see my time has elapsed.
You may answer the question.
Certainly, a police officer who is winded and has his hands full may not be in the best position to fully apprise a suspect of their rights, but that doesn't make the suspect's rights any less valuable, nor does it explain the failure to properly explain those rights when the petitioner was sitting at the station house about to be questioned. These rights were read to him twice once in the station house, no matter the circumstances of the foot pursuit, no matter the circumstances of the arrest, there is certainly an opportunity before questioning when he's sitting by himself waiting to be questioned.
All right, well, let's change the facts. Let's say that this same warning is given in the field and then the person confesses. Are you saying that that would be okay, but because we're now back at the station house and they actually can pull out a card, that there ought to be a different rule? Should there be a different rule in the station house and in the field, and would this warning be adequate in the field where a person didn't have time to pull out a card, but a different warning has to be given in the station house?
First, I think that the hypothetical you've put forth is going to, in which a suspect immediately confesses following a lengthy foot pursuit, is going to involve a very small number of cases. But you can't undermine the suspect's rights by claiming that it's easier for the state, it's convenient for the police officer to give him the wrong explanation of his rights. If this right is to mean anything, it has to be delivered correctly each and every time in order to, or else it's meaningless, and the police could just as easily claim, given the circumstances, in order to make their own jobs easier, that they were in the interest of doing their duty, in the interest of actually detaining the suspect. It was inconvenient for them to fully apprise him of his rights. For these reasons, the petitioner requests that this court overrule the Supreme Court of Ochconsin, hold that under the Fourth Amendment, the petitioner was seized when the car was pulled to the side of the road, and suppress the statements made to the officer as a result of the flawed Miranda warning. Thank you.
Thank you, counsel. Case will be considered submitted, and the court will take a short recess.
All rise.
Also knew that we will have a decision shortly, and afterwards we're going to have a wonderful reception co-sponsored by Thompson Hine, and that'll be in the Birdman Lounge, which is right down the hall on this floor. So please stick around for that.
All rise.
May be seated. The court has come to a decision. We thought it was exceptionally close. In fact, we wavered around a lot, but we have decided to give judgment for the petitioner and his counsel, Mr. McGinn. Congratulations. One of the things we talked about, all of us, was that you should not have conceded that Prowse was dicta. Because we think there's a good argument for that it isn't. And it's one reason that the circuit courts have gone primarily in that direction. It'd be interesting to see what the Supreme Court does in this case. You were both very good at responding to questions. It always amazes me when I do one of these, how much better the oralists are in these competitions than most lawyers in most cases are at responding to questions. Yeah. So I know it's a lot of work for you, but I think this moot court is a terrific experience and one that will serve you in good stead, whatever you do. Judge?
I would echo those comments and compliment each council on really an excellent job. And again, it was very close, and I know we all appreciate all the work that you've put in and that the board has put in organizing this event. So we commend each of you and the entire Moot Court Board for doing this.
Yeah, I thought you were both just superb, and I'm glad you weren't born 17 years ago when I was doing Hardt Cup here. You both would have smoked me easily. I had no idea. My first round of Hardt Cup, I had no idea what I was doing. And I lost the first two, and then a light bulb kind of went off, and I began to get sort of a hang for it, and I won the rest of them, or 3 out of the next 4, but I was pretty pitiful early on. But you were both superb, and would really outshine probably the overwhelming majority of lawyers that appear before the court. I mean, from day one, you guys would just be phenomenal. So I think you'll do very well from day one, and I really can't commend you enough. I thought it was really exceptional.
We wish that there were 2 cups that we could give. But we can't, and unfortunately, somebody has to lose. But thank you both. You were terrific. Court is adjourned.
To Mr. McGinn.
Big cup.